Fast forward, by July 4, 2025, she filed the case at the ECOWAS court,
right.
by which time she was demanding 10 million in damages for what she says that was not a right process. The Human Rights Court heard the application. They are yet to deliver their judgment on that particular one. And this was in respect of the ECOWAS court. That was not done. She went back to the High Court, this time around, filing a judicial review, basically challenging the procedure that had been adopted by the committee, and also alleging the breach of human rights.
Absolutely. And these are cases that are still in motion, and the courts have not determined that outcome.
Yes, for the
of it
substantive ones, yes, but the injunction applications, those have been determined and
already
dealt with.
Perfect. And let's stay the steam on that, and let's go on to Zoom right now. Martin Pebo is private legal practitioner, and is one that we've been engaging right from the beginning of this entire process, where 3 petitions at the start. That's what we were told at the start of it. 3 petitions were received, and it was the first petitioner, Daniel Ofori's petition, that formed the basis for this recommendation by this committee headed by Justice Gabriel Scott Palmer, whom you see right there presenting the details of this report by the committee to the president. In that brown envelope, the president received it. You have all the other members of the committee as well seated at the table with the chair, Justice Scott Palmer, who presented it, the Chief Justice, that's the Chief of Staff as well, was there. And Martin Pebo is joining us on Zoom right now as private legal practitioner. Counsel, good evening. Thank you very much for joining us. And when we started this conversation months ago, you had indicated that it would have served the now removed Chief Justice some good if she had resigned right from the beginning of this. Well, the process has gone full scale, and this is the outcome. The president has communicated a decision to have her removed from office based on the recommendations of the committee and their findings on Daniel Ofori, petitioner 1's petition. Counsel.
Yes, well, so like they say, the law is the law. So at this juncture, the law has taken its course, and so that will be it. We're hoping that this will bring closure to this case so that we can, go on to concentrate on other matters of improving the judiciary. Yes, I mean, my position, as I said earlier, I was hoping there would be a window for her to resign way from the beginning. But, it didn't happen. Also the Supreme Court too had held that in the Justice Adorye case and also in the Frank J. Chum case, that once they start the hearings, then the respondent, that's to say in this case the Chief Justice, has no right to resign. I was hoping there would be a political settlement that would have resulted in a resignation. But as I said, that was hope. But all of that didn't materialize. So once the committee is done with its work, and then that's based on the first petition alone, and once she's been removed based on the first petition alone, I mean, well, that's it. We will see whether the committee will have the appetite to go into the other 2 petitions. It doesn't appear it will be a good use of our time, but that's just my personal opinion. Let's see how it goes. So Article 146, well, that's been it. We're hoping also that going forward, the Constitution Review Commission, based on what we've seen in these proceedings, would strengthen the provisions to make them better in future. I think that's what I can say for now.
See, and you're saying indeed the case that the decision of this committees to have the Chief Justice removed was on the basis of the details of the first petitioner, Daniel Ofori's petition. So the other 2, you'll say that, in your view, it would not serve the good of time if the committee goes into the other 2?
Absolutely. Absolutely. Yes. Because right now she's been removed. And so once she's been removed, I'm wondering what good it would do to continue the hearings. But in law, well, it's allowed, because once the cases are still before the committee can go on. It would also be within the right of the petitioners to withdraw, to say, look, okay, if Madam Torkonuu has already been removed, they want to withdraw from having their cases heard. Yes, so that maybe, because you see, I'm saying this because let's not also forget, Madam Torkonuu fought this case every step of the way. My colleague, Wedam Puabri, has already, gone through, both of you have gone through the milestones. The, filing a case in the ECOWAS court, now the final one being the so-called group of the Bar of England and Wales jumping in, a letter that a lot of us had issues with in terms of its authenticity, not being signed, and the language in the letter, etc. But whatever it is, there was such traction, that at every point she sought to fight back, and the various fora, etc. she's been to have resulted in a way in giving us bad press. We can't run away that we've suffered bad press, a reputational damage to the brand name Ghana, because you see the kind of things that the so-called Bar of England and Wales wrote in their letter. The Commonwealth Lawyers Association also wrote earlier on. You see all that language taking us to the ECOWAS court. All those things and the allegations of bias and all that, they've hit us. They've damaged us a bit. So for me, usually if you can avoid litigation, avoid it. It's even in the Bible. But the Bible says that, hey, if your brother, somebody is taking you to court and you can settle the case on the way, settle it before you go and then you get thrown into jail, right? There is something like that in the Bible. So in this case, we are looking at protecting the brand name Ghana. We are quite a strong democracy in this sub-region, but globally, we are still a fragile kind of democracy. So when there are issues like this being circulated internationally, it reinforces the notion that we are still not that much capable of running our own affairs. So it's in that context that I was hoping that maybe the second and third petitions would not be gone into, so that we can, have closure.
But you made the point about the Chief Justice challenging this process every step of the way. And the details as Justice Kwaku Annan gave today complements that point that you made, because the committee had evidence from 13 witnesses on behalf of the petitioner. The Chief Justice, the now removed Chief Justice, also testified and was cross-examined. She called 12 witnesses, including experts. In total, the panel said they received approximately 10,000 pages of documentary exhibits from both sides. Each side was represented by 4 lawyers. It's a very meticulous process we've seen play out up until this point, is it not?
Yes, absolutely. Yes, it's been grueling. Yes, because, to have 13 witnesses for the petitioner, 12 for respondent, 25, and you see each one of these was given evidence. So that's what we call evidence in chief, right? Through the witness statements that the witnesses filed, then cross-examination. So cross-examination of all these 25 persons. It's a lot. It's not a joke. That's quite a robust process, rigorous and robust. And of course, it's taking a toll. Because from dispatches that we could hear, for them to have finished this quickly, they would go in the morning and close in the evening. So it was usually a full day's work, morning to evening, right? A number of days in the week. So it's been a lot of work. Yes, that one we can't run away from it. And in natural fact, we should commend the committee and everybody involved for cooperating for this work to be done in such a time.
And we know that the Chief Justice has a dual role. As a judge or a justice of the Supreme Court, and then also the head of the judiciary. Now, she's been sacked as the Chief Justice, essentially the head of the judiciary. What happens to her role as a Justice of the Supreme Court?
Okay, yes, so with this, it goes the two of them. Yes, it goes for the two of them because it's not that she misbehaved as Chief Justice separate from being a Justice of the Superior Court, right? No, they touch both offices because, yes, she's a judge of the Supreme Court and also at the same time Chief Justice. The matters that were raised are matters that if a judge, ordinary judge, were involved in and then there was evidence against that judge, the judge would be removed. So in similar vein, since the Chief Justice is a Justice of the Superior Court, and when we say Superior Court, that's High Court, Court of Appeal, Supreme Court, right? Yeah, so it's the same thing for Chief Justice and for any other judge of the Superior Court. Okay, so it can't be that she's been removed as Chief Justice, but she would come and continue as a Supreme Court judge. No. The law doesn't allow a Supreme Court judge to be engaged in the matters that were alleged to have been engaged in.
I see. And Counsel, stay on for me, if you will, just so we backtrack a bit. We recall exactly what the position of the now removed Chief Justice Justice Torkonuu was on the petitions brought against her when she addressed the press conference detailing her concerns a couple of months ago. Take a look.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
Let's get to it's about Torkonuu and the decision to have her sacked is what we're getting into. It's a breaking news that came through some few minutes ago here on TV3. It's a statement from the presidency detailing reasons why that decision has been taken as upon the recommendation of the 5-member committee that was established under Article 146 to look into the petitions against the then Chief Justice. And it was the details of the first petitioner, Daniel Ofori, that the committee made their recommendation on to have her sacked, and on the basis of that established fact of stated misbehavior. Martin Pebo is private legal practitioner, is still with us. Dr. Joshua Zato is a political analyst, a lecturer, senior lecturer at the University of Ghana Political Science Department, joining us as well. Dr. Zato, good evening. Thank you for joining us.
Good afternoon, and thanks for having me here.
Well, also, Martin Pebo, you had made the point about about Torkonuu considering resigning right from the beginning of this process. She had a response for you and others who were making that suggestion a few months back. She says that was really not an option on the table for her, and this was why. Take a look.
Yeah. Resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on.
Well, Mahamadu Bawumia, so that was it. That, look, this was even an option on the table for anybody going through that process because you stand the risk of losing your entitlement. Now, with this decision that has come, does that risk also now really play out in this case, that she stands the risk of losing all her entitlements after being sacked?
Absolutely, yes. So she loses all her entitlement because the meaning of the sacking is that she was sacked on the basis that she's been found culpable, she's been found liable to have breached certain rules, okay, whilst in office. Right now, I'm sure with time we will get to go into the rules, right, when the decision is made public, because in the Justice Torkonuu case, the Supreme Court said after the decision is out, that's after the proceedings are completed, the secrecy or the in-camera protection should go off. So we'll plead with President Mahama to give us a copy of the report of the committee so that we will see what findings were made. Because in the Justice Torkonuu case, the Supreme Court was very clear that after the decision has been made, that cloak of in-camera protection, the secrecy, is no longer necessary in a democracy. It's no longer necessary in a democracy. And the Supreme Court went ahead to compare the cases in South Africa and other countries, right, around the world. So the Supreme Court is very clear that the decision can be made public, that's the committee report, etc., after a decision has been made. It's not meant to be kept secret. And in this particular case, even Justice Torkonuu herself had waived her right, but eventually it was generally agreed that even though she waived her right to an in-camera hearing, it was agreed that based on the decisions of the Supreme Court, etc., the provision in Article 146 asking for in-camera hearing was not meant to benefit Justice Torkonuu alone. It was also to protect the whole system. So it was agreed that the proceedings should continue in camera. But now that the proceedings in Petition 1 have terminated, in the Justice Torkonuu versus Tiger IPI and Attorney General case, the Supreme Court said afterwards we can get the details, get the petitions, get the reports, so that we can dissect and see where everything went well, and if some places didn't go well, naturally people will comment so that tomorrow we will not repeat such mistakes. Yes, so Mr. Okan said that is it. And now when it comes to the matter of there was no option to resign, remember that I said that if we wanted to get a resignation, there are 1,001 ways of doing it. But as I said, right now, we've gone past it, so it's no longer possible. So let me tell you what I was thinking. You know, matters like this, it's a civil case, right? So there could have been an agreement that, look, okay, I want to settle this case. I want to resign. Like, can I do a resignation letter for you to see so that then you will withdraw the petitions? Then she would have walked away, okay?
Right.
But as we're saying, it's because the Supreme Court said when the proceedings start, you cannot resign. There are two Supreme Court decisions. And I was saying that, because she's Chief Justice, at that time I was scared of all the places she was going to go to. Remember the time I kept saying we should allow for a resignation? You know, that time she hadn't gone to the ECOWAS court. And at that time too, she had the bar of England and Wales hadn't jumped in. So you remember we had seen that the way she was fighting it, we're going to suffer more embarrassment. So I was looking for a political settlement. And so sometimes, you know, they will tell you that the law was made for man. But, I mean, bottom line is that generally it looks like not many people sided with the resignation thing. It's a democracy, so we'll go with the majority. You remember also, yes, lawyer Asare also supported the resignation route because we could have saved there and then, you know, so there could have been a settlement. This is a Chief Justice, so this is a Chief Justice, not any other Justice of the Superior Court. She's a Justice of the Superior Court and specifically Justice of the Supreme Court and also Chief Justice. So, I mean, to every rule, you hear there's an exception. But bottom line is that it didn't work. So we use the law, strictly speaking.
Right.
And like Justice Torkonuu herself had said in the past, the law is the law. So, I mean, we have to abide by it. Sometimes the law is difficult. It's painful to abide by the law, but the rule of law demands that we should abide. Yes.
Indeed. Ahmad Bebo, thank you. And kindly stay with me. And this I bring in Dr. Joshua Zato. You had also indicated that for you, the Chief Justice was a goner, even before today.
Oh, you remember that, right?
I do, because you said it so many times without number.
I thought you forgot. Alfred, I'm a soothsayer. I should be a soothsayer of something, or a prophet. You know, they should call me Prophet Jebunti. Let people come to me, I'll prophesy for them, and I'll make some money, you know? That'll be a good thing. I should be a prophet or something, you know?
You sound fulfilled.
I did. I called it. I told you, listen, the Chief Justice was an impediment. She was a means to an end. The end is the EC chair and her deputies. And I'm going to make another bold, prophetic, angelic prediction today. They are next. Very soon you will see the petitions for the removal of the EC chair, her deputies will roll in. And I'm telling you, by the end of the year, the CJ has gone, the EC has gone, the whole slate is going to be swept clean, and then you are going to have NDC people planted there to continue the NDC process of going forward. So yes, I'm very, very certain about this, and it's going to happen. Just watch this space.
Well, but then, as was clearly indicated, this is a constitutional process that was at play, specifically detailed in Article 146, as we've seen play out. And the President's decision was based on the recommendations of a committee, and he did not take that singular decision. Dr. Zato.
I have no problem with the constitutionality or otherwise of it. But you also then realize that every aspect of it, every single phase of it was what? Laden with politics. Now, this is what history will remember. History will not remember constitutionality, no. History will remember that under this constitution, in this Fourth Republic, it was His Excellency John Dramani Mahama who was the first to fire a sitting Chief Justice, a member of the co-equal arms of government. History will remember that. History will not forget. Tomorrow, I'm sure that if people start teaching law, constitutional law and other laws, they will always bring this up. And whenever they bring this example, they will say, His Excellency President John Dramani Mahama removed the Chief Justice Torkonuu. And so far, it is probably the biggest achievement of this government is the removal of the Chief Justice. And that is what history is going to remember. And that is what politics is going to remember. And that is what going forward, everybody is going to remember. So you can call it whatever you want, or you can lead in it whatever you want. You can hide under every single judicial or legal interpretation, whatever. But the history will remember the Chief Justice was removed by His Excellency John Dramani Mahama, and it's the first time it ever happened.
You've indicated that you have no problem with the constitutional provision as it played out in this instance. And it is the same.
There's nothing I can do about them.
Yes,
I cannot change the constitution.
I was coming to a point. And it is the same constitutional provision that you don't have any problem with, that also empowered the president to take this decision based on the recommendations of a committee established under this same provisional constitution, the constitution of the republic, that you are not having a problem with. So how then do you say that it's a decision that the president has taken to sack the Chief Justice without also taking into consideration the provisions of the Constitution that detail the process that has resulted in this decision today?
No matter how you call it, you say it was His Excellency President John Dramani Mahama who sacked the Chief Justice. That's a fact. It doesn't matter whether it's a constitution or not. He sacked it. He wrote the letter saying, you are sacked, you are fired. 1. 2, I've also explained on previous occasions, maybe I should rehearse it now. The whole process was laden or interwoven with politics, and it is the politics that we've seen coming up. We can rehearse some of them. One, the reason why we do not see the Council of State's charge sheet, we don't see their recommendations, is a political decision. Akufo Addo showed us the Council of State reasoning. President Mahamadu did not. That was a political decision. Two, when the decision came, the decision to suspend the Chief Justice was a political decision. It was a judicial decision because the President could have still exercised his discretion, allowed the Chief Justice to stay in office while the committee decided the case. That's also political. Three, even when to submit the report to the Council of State was also political. The President could have received it and say, yes, I've received it, but he could have kept it for as long as he wanted because the Constitution did not say you must submit it to the Council of State within a week, within 2 weeks, within 3 weeks. It was up to him. So I'm saying that in all these instances, and even the decisions of the Council of State, remember, it was the National Communications Officer of the NDC that announced the verdict of the Council of State to us. The Council of State never told us. He was the one who told us that the Council of State voted 30 to convict and 1 abstained. That decision to leak the information, to get information up to the communications director of the NDC was so political. So I'm saying that every single step of this process had politics interwoven into it. The discretionary powers being exerted were political and partisan. So you cannot decouple the politics from the law or the constitution in these cases. They were in tandem, they worked together. The politics was used to grease the wheels of the constitution of the law so that these things will go faster.
I see, but then the fact that you conclude with that statement that this for you is a political decision, even though, as you indicated, you acknowledge the constitutionality of the process. Those are two very different positions that do not merge at any point. If the constitutional process details... I'm telling you that... I'm coming to a point. If the constitutional process details what was at play, what could the president have done, really?
So, and I've just told you what the president could have done. One, the president could have taken once he received the thing, the decision on when to send the Council of State was up to him. He could have kept it and not send it there. Acknowledge receipt of it, never send it there. He could have done that. Two,
no,
when the council,
you're saying that power rests on him. There's the provisions of the Constitution.
When he can submit it.
No, that's what I'm saying. If you are abreast with the details of Article 146 from 6, Clause 6 all the way, you would understand why maybe the point you are making also would be a bit problematic in the sense of what the provisions of the Constitution is. So that if the president receives the petition, the process starts. He is bound by that constitutional provision. So you don't say that he could have, decided not to forward it to the Council of State. That's not written in the Constitution.
He gets to decide when to forward it, right?
The Constitution mandates him to do so.
Good, but the Constitution tells him when to do it.
But that's what I'm saying, that the process just plays out after the receipt of the petition.
So the process, I'm saying that how fast, or in this case, how fast or how slow the process goes was then determined by presidential discretion.
But that's the Constitution at play, regardless of the discretion of the president.
So, see, again, you and I seem to agree on the same thing that, look, there is Constitution, I'm not saying, but then there's also politics. Again, listen, he received the report today, we are told, fired the woman today. He could have taken some time to study it better and fire the woman later, right?
But
he could have done that. That's also discretion. Secondly, I'm saying that. Go ahead. Let me hear your question.
Well, so that I continuously reference the dictates and the details of Article 1466, which you acknowledge. You say you don't have a problem with that, but then again, you say that the president could have exercised discretion, and I'm telling you that the dictates of the Constitution, as stated in Article 1466 to 10, does not necessarily give some room to the president's discretion. The president is bound to follow the dictates of the Constitution. That's what I'm trying to bring your attention to. But this is where I bring in... hold on a bit for me. Hold on a bit for me. Lawyer Christian Mamhesi is joining us as well. This is private legal practitioner. And So, can you hear us? Good evening.
Yes, good afternoon, and thanks for having me.
And this is why I bring you in about this, the position of the law and how this process has played out. Dr. Zato is of the view that it's the discretion of the president at play, dotted in the exercise of the constitutional provision. The point I was just trying to draw his attention to is about what the dictates of the Constitution is. That when the petitions are received, the process kicks in and the president is bound to do so. Is that the position of the law?
Yes, I mean, rightly so. When the recommendations are received, the law does not put time limitation on it. But I mean, I can understand where he's coming from. And that gap could be filled by political inferences. But as far as the law is concerned, there is no time gap. The president, upon receipt of it, could act immediately, and that's what he did. And there's nothing unconstitutional about what has happened.
I see, and this is the process that has been at play until now, that we've seen the outcome of this particular process with the decision to remove the Chief Justice after the recommendation or upon the recommendation of this 5-member committee which submitted its report to the president earlier today. Is this one that you expected as well, based on the knowledge you have of the details of this petition, specifically the first petitioner's petition upon which this decision was taken?
I mean, because the matter was heard in camera, it would be prejudicial or difficult for anybody to speculate what the conclusion of the committee would be. And just as we have it, it's in camera as required under Article 1468. And given the period of time, there were parties or persons who testified for and against the learned Chief Justice, as we got from the news portals and all of that. But as to what the testimonies were, to us again, run the probative value in what they put out there. So probative value basically means that the evidentiary weight in what was put for and against the removal of the Chief Justice is quite unknown, but the conclusions of it would be before, or as it were, before the president, and based upon Article 146(7), the president has taken a decision to remove the learned Chief Justice.
I see. Now, we've seen this process play out till now, and we also do know that the Chief Justice decided to take a case to the ECOWAS court. That court has not delivered a ruling as yet on this particular case there. Does the ECOWAS court have any jurisdiction whatsoever to, as it were, vary the outcome of this committee's decision?
Oh, yes. I mean, because of the fact that Ghana is committed to the ECOWAS Treaty and the amendments that were made early in the 2000s, Ghana is committed to the ECOWAS court. And for whatever decision that the ECOWAS court would reach, Ghana will be amenable to it, based upon human rights infractions, if only they conclude as that.
Now, I was asking earlier about the options that were thrown at here at the beginning of this entire process by the likes of Martin Kpebu, whom you were with earlier. His point he made earlier was that the Chief Justice, now sacked, could have saved herself all the trouble of going through this entire process by stepping aside right at the get-go. Now, the sacked Chief Justice was of a different view, that if that had happened, she would have lost all her entitlements. Now, we do know as well that this particular decision is what the law captures. But stay with me, Ma'am Hesse. I have the Minister in charge of Government Communications, the Abrasegu Kwamankese Member of Parliament, Phyllis Kwachu Fosu, who signed this statement announcing the sacking of the Chief Justice, joining us on the telephone right now. So, Ato Forson, good evening. Thank you for joining us.
Oh, good evening.
Now, we saw the committee members submit their report to the president moments ago, and then the decision communicated. I want to find out from you, first of all, whether this particular development today is one that, in the end, brings all of this to a close. We're moving forward.
Well, I believe so, except to say that the chairman of the committee, in the presentation of the committee's report, stated that there were 2 outstanding petitions that they had not looked into because they had received representations from the parties involved for an adjournment of hearing into those matters. But with respect to the Daniel Ofori petition, there was no such request, and therefore they proceeded to look into it. And it was on the basis of their work on that petition that they have recommended the removal of the Chief Justice, which the President has done, as communicated in the statement that I issued a while ago.
I see. And so the other 2 petitions, any indication that the committee is minded to get into it, or because this really is the ultimate outcome, that if the process had played out, either or not, or whether or not she was going to be removed or otherwise, now that she's been removed, well, the likes of Matik Bebo say that the committee should not waste their time getting into the other 2. Any indication of what the committee's decision is on the other 2?
Well, government is not in a position to dictate to the committee how they should or when they should do their work. So it is entirely within the purview of the committee to decide what to make of the outstanding 2 petitions. But the president has acted strictly in accordance with the constitutional stipulation that enjoins him to carry out the recommendations of the committee. That is what has happened today.
How do you respond to the likes of Joshua Zato on the other line, who says that all of this process was dotted with politics, even though it is stipulated in the Constitution?
Well, being an MPP partisan, you would expect him to take a position similar to what his party has taken. If he doesn't furnish any basis for that position, except to make it, just like his party propagandists and members have done. But everybody who is fair-minded and has followed this process will be clear in their minds that the president has stuck strictly to constitutional provisions. As of the MPP, they can abrogate and reproduce that when they want. When they were in power, the same Article 146 was used to remove the then head of the Electoral Commission, Madam Senator, and 2 other deputies. I didn't hear Dr. Zato offer a whimper on that occasion and express any belief of political motivation. Certainly, political motivation has been invented by him to smear this process in order to achieve a certain political end. I don't think that is the kind of discourse or commentary we should be having on this particular matter. Let Dr. Zato and the rest of them in the MPP point to any specific infraction on the part of the president in respect of his handling of this matter. He will find that, and indeed, till date, nobody from the account has been able to point to any infraction, or no other person in any quarter within our society has been able to point to any infraction. That tells you, that shows you clearly that the President has acted above board. He has acted within the remit of the law, and that is what the law says should be done.
I see. Well, it says the president could have exercised some discretion in the pace at which this was executed, and that really, after receiving the petition, he could have decided not to forward it to the Council of State.
How so?
That's
all read the Constitution. Which part of the Constitution is that the president can decide not to forward it? The Constitution is clear that upon receipt of the petition, the president shall, in consultation with the Council of State, determine prima facie. That is the wording of the Constitution. How then does Dr. Zato decide on his own that the Constitution should be disregarded because he believes that his party must show their support behind the Chief Justice? I don't think that we can, entertain that kind of logic.
Okay.
It is completely wrong. What he is asking the president to do is a violation of the Constitution. Indeed, the president will be liable for removal from office if he fails to act in the way that he acted.
Okay, Mr. Kwachu, so order the best. Dr. Zato, yeah. So, what was the?
What do you call it? You called me to have a debate. You didn't call me for a debate.
No. Not at all. Yes, but
As you can imagine, there are many.
There are quite a number. Yes, I respect that, but I just want to find out from you, and let me stay a bit for. And Dr. Ato, I'll come to you. Yes, but now that this decision has been communicated, when will the process for the substantive Chief Justice be named start?
Yeah, I think that it is only a matter of time. In consultation with the appropriate authorities, the president will make the appointment. Then it will be communicated to the people of Ghana.
I see. Dr. Kwaku, appreciate your time, and I thank you so much for joining us.
The pleasure is mine.
Felix Kwaku is Minister in charge of Government Communications, and then also the Member of Parliament for Abrasebo Kwamankase constituency. And Dr. Zato, yes, you were quickly. And then I'll acknowledge a few persons joining us. Yes, Doc.
Should not submit the report to the Council of State. That was wrong. I didn't say that. I said the time, the speed with which he submitted it to the Council of State was based on his discretion. He has to submit it, but when he chooses to do that, it's based on discretion. That's what I say. So if you say, I'm not a lawyer, but I can also read the constitution that says that the president must submit it to the Council of State. But when he chooses to do it, it's based on discretion. So the way you presented it to Felix was wrong. That's not what I said. Secondly, I also did make the point that the decision to release or not to release the report of the Council of State was also based on what? Discretion.
I think it was quite clear at the point I made that you indicated the pace.
That wasn't what Felix said.
You said the pace. The pace at which, and then
exactly.
And he could have exercised.
That was what Felix said. He wouldn't have responded the way he did.
You said he could have exercised discretion in the pace, and he is making the point that is not stated in the Constitution as you say you have read it. The president is bound to take action.
Good, but when he takes it, it's up to his discretion.
Let me bring in Solomon Owusu. He is a member of the Movement for Change. He's also a political analyst. And Hesse Mam is still with us. He's a private legal practitioner. Mam Hesse, is that position espoused about the discretion of the president even founded in law? Does it have any definition whatsoever or grounding in the law as stipulated in Article 146? Hello, Lawyer Hesse Mam? If you can unmute for me. Can you hear me?
Oh, no, I've not muted.
Yeah, yes.
Can you come by your question again?
I was asking that, does that position about the president exercising discretion as to how quickly or otherwise he submits or refers petitions received to the Council of State grounded in law or the dictates of Article 146 as you do know it?
Okay, if I hear your question well, are you asking about the time as required? Because I hear Dr. Zato making that
exactly.
proposition.
Yes.
Is that what you're asking?
That's the point that he was making earlier. Yes.
I mean, just as I submitted early on, the Constitution does not provide. You see, these are minute details, you know, and the Constitution does not deal with the minute detail. It deals with broader constitutional provisions. And the Constitution under Article 1467 indicates that the recommendations will be made to the president, and the president would act on it. Definitely, the president would act on it with advice from the Council of State. It does not give that framework of time within which this would be done. And so, given the fact that the president has satisfied this constitutional provision, it could go ahead to act on it. I mean, it is a discretion of the president to decide to wait a day after, 2 days after, 3 days after. But at the end of the day, once the president acts under the details of the Constitution, there's no infraction or whatever. But like I said, in the political theater, a lot of political inferences could come in. But once it's legal or under the law is direct and is positivist. So what the law says is what will be done, and that's what the president has done.
All right, and stay with me because Solomon Owusu, can you hear me? Good evening, thank you for joining us. And this is the decision of the 5-member committee as communicated to us by the statement by Phyllis Kwachofosu, whom we just spoke to, detailing exactly what the committee's recommendation was upon the first petitioner, Daniel Ofori's petition. They recommended the removal of the Chief Justice, which the President has acted upon on the basis of that's stated misbehavior as one of the 3 grounds for the removal of the Chief Justice, as we've seen. Did you see this coming?
Yes, I saw it coming, and some of us advised. You remember on numerous occasions, some of us attempted the Chief Justice to go and negotiate a way out. But unfortunately, she had bad counsel. She had people around him who, to us, it were turned this to political, and that is why she got herself entangled in some of these days. Later than Ofori, people do not know the astute businessmen in this country. He does not just get up. He's not someone that you can be pushing around. He raised 21 issues of misbehavior and 4 issues of incompetence. Who would do that and think that the Chief Justice get away with it? It was on solid grounds, and it was the reason why some of us said, look, we need to protect women in public space. So, madam, go and negotiate your exit and let us have peace. Take a cue from 8 for task of the U.S. in the 1960s and also walk out on Nigeria in 2019 and then get out the radar. She did not listen to anybody. Nothing the President did that has not conformed to the constitutional provisions that you operate with. The President has operated within the Constitution. A petition was sent. He received a petition in consultation with the Council of State. A committee was established. Throughout the process, when the matter was supposed to be heard in camera, we had the Chief Justice supposed to make the law, flout it, come into the public space, hold the press, take the country into ECOWAS, take us to Supreme Court, take the country High Court. All these processes have been gone through, and if the outcome is that she be removed and the President has acted, I think we have to rather clap for the President rather than saying otherwise.
I see. But then also, we'll see this particular issue of the politics of things being read into it. We've had the law also at play, as explained by the lawyers, about what exactly has resulted in this decision as we are seeing now. You seem to have a clear knowledge about who the first petitioner is. But this 5-member committee, looked at the petitions and then also made their decision and recommended what they did to the President. In fact, from what we do know, the Chief Justice testified and was cross-examined. She called 12 witnesses, including experts. The petitioner, Daniel Ofori, also had evidence from 13 witnesses on behalf of the petitioner. And then the panel received approximately 10,000 pages of documentary exhibits from both sides. That's according to the details, as we do have it, from this committee's work that has resulted in this particular decision. Mr. Owusu.
I mean, that's the petitioner knew what he was about. He was not one of those that just will level it against someone without evidence. He to court with to the committee with evidence to prove his case. And I think we must encourage some of these things. I am not of those. I'm not one of those that believe that it must be too difficult to remove people in the position. And we must not also take those who are saying it's a political which are serious, because the very position of the Chief Justice is a political position. If the Chief Justice is appointed by the President, it makes the political position. And so, it has its own political dynamics and legal dynamics. And I'm saying the legalities. There is no lawyer in this country who has been able to convince me that due process is not followed, right, from the beginning. So, well, I think there was anybody that supported provisions in the Constitution. Justice. When matters were to be heard, she decided to come into the public space to hold a press conference and expose what was going on in the committee posts. I thought that was fun. And so we have gotten to a stage where a decision has been made and she's removed. And we move on as a country.
I thank you, Mr. Solomon. Also, thank you as well, Dr. Joshua Zato. Thank you, gentlemen. Thank you for joining us. And lawyer Christian Mamhesi, Dennis Paberi Wadam Esquire is also going to be joining me in a bit. We'll get a bit more into how the path has been up until this point, a decision that has been taken. If you're just joining us here on TV3, also live on 3FM 92.7, the breaking news that we've been getting into, we brought to you almost an hour ago and over, is that the President, John Dramani Mahama, in accordance with Article 1469 of the 1992 Constitution of the Republic of Ghana, has removed the Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Torkonuu, from office with immediate effect. Now, this follows receipt of the report of the committee constituted under Article 1466 to inquire into a petition submitted by a Ghanaian citizen, Daniel Ofori. After considering the petition and the evidence, the committee found that the grounds of stated misbehavior under Article 1461 had been established and recommended her removal from office. Under Article 1469, the President is required to act in accordance with the committee's recommendation. This is what has resulted in this decision, as we're saying now, by His Excellency the President of the Republic of Ghana, John Dramani Mahama. And then, as we did indicate earlier, this committee has been at it for quite a while now, getting to know the details that the Chief Justice, in fact, also testified and was cross-examined, and she called 12 witnesses, including some experts as well, as per the details as we have it from this committee's work.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.